Any mention?
Yes, please, Lordship. Lordship, I beg to mention item number 6 and 7, Lordship. Here, I was supposed to file the additional affidavit in item number 6. I have filed it yesterday, Lordship. So I need some more time. I have filed it yesterday, Lordship. So
Lordship, yes.
okay, 6
How long? How long you want?
2 weeks, Lordship.
This 6 and 7.
Then item number 10 also will have to go, Lordship, because it has been taken.
This is matter for 2 weeks.
Item 10 also will go, Your Lordship.
Item 10 also. Who is
Because it
outside?
has been listed along with these 2 items.
Item 10.
10.
Yes, Your Lordship.
Why it is listed together? Sir?
Yes,
This
this
is
is
concern regarding the Hindi teacher, Your Lordship.
Yes.
This for the petitioner.
Item 10.
Yes, my lord.
Now you understood what is happening.
No, my lord.
Is this matter tagged together with 6 and 7?
What is
Yes, Lord.
6, 7, no? 6, 7.
But then, is there any order, Mr.
Lordship,
Take it
I
together.
think there is an order.
Now, if 6 and 7 is 7 are adjourned, then this also will be.
This
adjourned.
Will have to be adjourned, Your
Yes.
Lordship.
Okay, this also. This item 10. Item 10 you just says requested by both the parties. This is matter.
Mas.
The other two, Mr. C. Yes.
Maso.
Oblige, Your Lordship.
Yes, Mr.
My lord, I like to make a mention of item number 12 again, my lord. My lord, one question that has fallen from my lord in this, whether when the judicial order has put a quietus to a matter, can an executive revive the course of action, my lord? We were trying to look into the exemptions under what circumstances. Simply saying it cannot. Simply saying cannot. But we are looking into some exemptions. Some interesting facts are coming up. I mean, like, some points are coming out. So kindly give me one more week, my lord. I know
My written argument is ready otherwise.
mine also it is ready, but this point, my lord.
Written argument is needed here.
Lordship is asked for actually bullet points. Those are
Bullet
ready.
points, my lord.
Written argument would basically,
Yeah.
in this kind of things, I don't think issue is very complicated here.
It's not.
So
It's not.
It is not, my lord. So these issues that my lord has fallen from my lord is quite interesting. And then we are looking into exemptions. Looking simply directly, it can't, it cannot, But
and we'll have it after 2 weeks.
2 weeks, my lord. Grateful, my lord.
As requested by Mr. P. Ewing. Yes, prayed for by Mr. P. Ewing and not objected to by Mr. P. Ewing, learned counsel for the petitioner and not objected to by Mr. Shan. Learned GA appearing for the state. This is matter after 2 weeks. Yes.
Oblige, Lord.
Obliged, Lord.
May I please, Lordship?
Yes.
I beg to mention item number 13.
Yes.
Lordship, I prefer 2 weeks' time. The conducting counsel has some personal difficulty, Lordship.
No objections, Lordship.
At the request of the petitioner, this is matter after 2 weeks.
Obliged, Lordship.
Okay, please, my lords, I beg to mention item number 11.
Yes.
Kindly grant us 2 weeks' time, my lords.
My lords, since the CO is not decided if this matter can come up after vacations, your lordship. CO of cantonment.
As requested by, as on joint request made by the parties. This is matter after 4 weeks. Make it after 4 weeks.
I'll oblige, your lordship.
Please, Your Lordship, I beg to mention item number 5. Your Lordship, this is a joint request. Okay, it's a joint request, Your Lordship. Let it come
Joint
up.
request.
Yes, Your
As
Lordship.
of now, you are the only person who is making request. Yes, when do you want it?
After 2 weeks, Your Lordship.
At the joint request made by the parties, this is matter after 2 weeks. Yes.
May it please, Lordship. Lordship, I beg to make a mention of item 3.
It is not a joint request. Yes.
I have no objection, Your Lordship.
It's an important matter. And it will just keep on going like this.
No, Your Lordship.
Then, do you really intend to finish these matters?
Lordship, 1 week accommodation, Your Lordship, may be granted. Senior counsel is having some personal difficulties, Your Lordship.
Let's say this also, sir. Mr. as preferred by the learned counsel for the petitioner and not objected to by the learned counsel appearing for the respondent. This is matter for 2 weeks. Yes.
Highly obliged.
Lordship, I beg to mention item number 8 and 9, as similar matters are pending before the Apex Court. So this matter may be listed after vacation, Your Lordship.
Item number 8 and 9.
Yes, Your Lordship.
A similar matter is pending before Apex Court.
Yes, Your Lordship.
But this submission has been recorded earlier.
Yes, Your Lordship.
Just on the joint pair of the parties. You see, the learned counsel for the learned counsel appearing for the parties informed that the matter pending before the Apex Court, that the matter pending before the Apex Court having bearing in the present matter is yet to be disposed of. Stop. That's in view of the submission. List this matter after
Vacation, Your Lordship.
after 6 weeks.
Obliged, Your Lordship. May I please, Your Lordship? I beg to mention item number.
Check the previous orders. Please.
I beg to mention item number 4. It is a joint request.
There also joint request. This is what is matter. This land acquisition matter.
Yes, Your Lordship.
This also one joint prayer made by the parties. This is the matter after 2 weeks. Yes.
Highly obliged.
Made His Lordship.
Yes.
What's the item number 15?
This is a perhaps this
This
is
is,
last item remaining in the list, isn't it?
No, my lord.
Yes, please.
Okay, this is in concerning my lord, that romantic relationship. If I may pray, my lord, romantic relationship.
Oh. Okay.
If I may pray, my lord, this matter also can be, my lord, referred to the division bench, my lord.
Why? What is the question? If you want, you just make a mention there, so it could be called. If you want. Otherwise, no question of just passing your order of reference. If you want it to be referred, then we have to pass a detailed order again. We have to hear you and then pass a detailed order. My lord. You just cannot refer it just on the basis of that.
As my lord pleases, since the issue is already pending before the
You can do one thing. You can, if you want,
yes, my lord,
you can make a mention there
before the division bench, my lord.
before the division bench, saying that there's a similar issues are pending, and then you may be given a right of hearing. So that will be better.
Would that be proper, my lord? Will that be proper mentioning before the
See,
division
that is, I cannot advise you, see this, but then you can try the 6. Otherwise, you see, if you want it to be referred, then we have to hear you. But then we will just see. But then will the purpose, will and purpose before. If you want to take part in the hearing before division bench,
yes, my lord.
I think that you know how to do it. You are a lawyer, isn't it?
Yes, my lord. As my lord pleases.
If it is solely for the purpose of you see allowing you to participate in the hearing.
Yes, my lord.
So if any issue is decided, normally it remains open for a court to allow.
Yes, my lord.
If any issue has a wider application, then in such a situation, it is always open. You must know how to take part. So what is your prayer right at this stage?
Here, praise my lord. I was praying for referring. If my lord.
So you want to, then you have to go for this thing,
You have to hear
hearing
the
of the
matter.
matter. But then is there any use when one matter is pending? Yes.
My lord.
Is there any use of referring a matter involving similar issue which is pending? Wait for disposal of the debt.
We can do
That is a
that
normal thing.
only for the reason that I can participate in the before
That
the,
you can make a
that
try
is-
before the division bench.
Yes, my lord.
And which way it is to be done, this court would not advise you. This is for you to find
My
out.
lord.
Possibly there will be a way to do that. It just says, yes,
We have no
that is same issue, isn't it?
Yes, Lordship.
Yes. Yes, prayed for by the land council for the petitioner. Place this matter after 3 weeks. Make it 3 weeks. Yes.
Supplement the cost list. Item number 1.
May I replace your lordship? Your lordship, I'm appearing for respondent number 3, your lordship. Lordship, in this case, we're still waiting for the mother's medical report because to file our affidavit in opposition.
You
Your
want
lordship.
some more time?
Yes, your lordship.
Yes.
Lordship, if this
Second
matter
window,
can come
London
up
Council.
after vacation.
Yes.
If your lordship permits, if this matter can come up after vacation, your lordship.
We'll give you 3 weeks time. You just see it. Wait.
Yes, your lordship.
What is the hurry to get the things listed after vacation? Vacation
Yes, your lordship.
is far away.
My
Let us
sincere
reach at least
apologies.
the
My
month of
sincere
December.
apologies, your lordship.
All the matters, Mr. Khan, the prayers are made for distant matters. Yes. I am Linda Leonard, Council appear for the response number 3. Praise for and granted further 3 weeks time for filing an objection in this matter.
Highly obliged, your lordship.
Yes.
Item number 2.
My lord, 4 and 5 has been served, my lord. The other respondents, my lord, 6, 7, 8 and 9, my lord, again return, my lord. So twice we have served, my lord. I therefore pray, my lord, Dusty maybe kindly allow us to send through Dusty, my lord. As per the order, my lord.
See, as per the order, you were supposed to file an affidavit, isn't it?
My lord, yes, my lord. On 13th November, my lord, we checked from the post office. We received a letter from the post office on 13th November 2024, wherein it is shown that the 2 persons notice has been delivered, my lord, on 12/11/2024, 4 and 5. The other, my lord, is returned, my lord, as per the post office records, my lord. So I therefore I'll file as status of service
See,
for
even the
this.
service report
Yes, my lord.
from 6 to 9 also has not come.
But my lord, on 19 November we have received another, my lord, from the post office.
No, but then so long you do not bring it on the record, we cannot give a record a finding on the basis of these.
Yes, my lord.
If you say that they are served, then file an appropriate affidavit.
My lord, I'll file for.
As of now, from the records,
Yes,
there is nothing to say that any of the respondents, that means except the state respondent,
Yes, my lord.
from respondent 4 to 9,
Yes,
have been served. So none have been served.
but I'll.
If you say if your submission is that they have been served, then such a case you bring the status by filing an affidavit.
I'll file an affidavit, my lord, for
Yes.
4 and 5.
Yes.
And I therefore pray, my lord, for other 5, 6, 6, 7, 8 and 9, I'll take Dusty, my lord, since we've received.
You file an affidavit,
Yes, my lord.
then only we can pass an order.
Okay, my lord, I'll file and file in status.
Yes. The office note indicates that service report that the report of service upon respondent number 4 to 9 has not yet been received. Stop. The petitioner to verify the status of service of notice upon the said respondents and file an affidavit to that effect. This is matter for 2 weeks.
My lord.
No, you verify and then enclose that postal
My lord,
certificate and then you
I'll file it. Oblige, my lord.
Hearing item number 14.
Yes.
Oh, sorry. Lordship, this case slightly unfortunate. I wish the other side lawyer was there in this case, because my only situation, Lordship, is this: there are certain arguments.
You are relying on that Madhya Pradesh judgment.
Lordship, yes.
That is your argument. That is, if you conclude, then we will pass that order. There is no problem. If now,
Lordship,
what you say, that this thing, that section 39 and 50, isn't it?
Lordship, yes.
If that is the thing, or have you concluded your argument or not?
Not yet, Lordship, not yet.
Because according to you, that a vehicle seized in connection with the offence under Wildlife Act will become a government property. That is what you are saying, isn't it?
Lordship, yes.
And then
there was a provision for interim bail, and which was amended, which was taken away.
Yes.
No, Lordship. Forest Act is a Forest Act. All the provision under Forest Act are substantive law. Most of the law. Now we have a situation under the CRPC. Part of CRPC, I'm not denying it, Lordship, that CRPC is not applicable. But the only requirement in Lordship, if I take a Lordship to pay 451 of the CRPC.
You are ready to conclude it today?
Yes, I'll make an attempt, Lordship.
No, it's up to you. If you say that you will conclude it, then we'll hear. There is no problem.
Lordship, I'll make one point, Lordship. If Lordship feels that this is sufficient, then I'll conclude. If not, if there's a larger issue raises, then Lordship.
What is your point?
My point, Lordship, is 451 and 457, Lordship, with the CRPC.
Is there any confiscation proceeding drawn here in this matter? Any confiscation proceeding is it needed to be drawn up?
As per the CRPC, Lordship, the seizure has to be done as per the.
No, confiscation. Is it needed? Any role of a confiscation?
Definitely, Lordship, yes.
Anything has been initiated?
Lordship, yes.
Confiscation proceeding has been initiated.
Something has the police, the forest office has done it. Yes.
Where is that order?
That Lordship you can find in the impugn order only.
Confiscation. The initiation of confiscation process, isn't it?
We'll just come to the impugn order. The impugn order is at page 23, Lordship, Annex 8.
Page 23.
Lordship, you read this is criminal appeal. The details, everything is here.
This is not order. This is not even a legal order. This is an absolutely, you see, illegal exercise of jurisdiction. So this is void ab initio. This order has no legal validity.
Then Lordship, we are left.
This order will go. This order will not remain.
Then the matter may be remanded back to the magistrate first class.
That is what.
Then you are correct. Lordship is correct. No, I'm not denying.
That is.
There are, Lordship is very correct. There's so much of irregularity.
Go through it. If there is an exercise of jurisdiction by a court which is not provided in law, then any order passed
is void ab initio.
In this thing will be inconsequential. It is
voidable order, yes. Voidable order power is there.
Appeal has to be a creation of judgment.
Correct.
There cannot be inherent power.
Absolutely correct.
So this order goes on that court. It doesn't remain. Now only remains the order of the magistrate. Now normally against the order of the magistrate, what remedy you have? Forget about that appeal. This is gone.
Against the order of the magistrate, Your Lordship, my remedy will be revision.
Before whom?
Before the session court.
Then why you are here?
Then? I am here because it has fallen from Your Lordship that this appeal order goes.
This appeal was filed at your instance.
Lordship is
not the other side.
Lordship is correct. I'm aware of it, Lordship. There's a limitation. On the face of it, there's something wrong.
There's a wrong committed by you.
Absolutely. This provision should not have been invoked. I agree to it.
Then why should we exercise jurisdiction at this stage?
Uh,
If you have committed wrong, you suffer for your wrong.
that point, that is a very valid point, Your Lordship. Yes. Only thing is this, Lordship, I am not in the position to defend myself. I am aware of it because certain.
This, so far as this appeal is concerned, just forget about it. Do not see this order is of no consequence.
Lordship, then if that goes, Lordship may not consider the appeal part of
So
it.
then
Let us confine 482 with the magistrate's order. Because in a peculiar
If
situation.
you have a remedy, why should we exercise 482?
No, because Lordship, yes.
See, just because you have chosen a wrong forum, this will not be a ground for assuming jurisdiction or 482.
Lordship, allow me to just clarify, because what has fallen from your Lordship is that in a 482 petition filed by a state, an appellate court order is found to be wrong. Appellate court order is under challenge. Now we are still under 482, so court has got options to disregard appeal part, but let's confine to the magistrate part then.
See, so far as this appeal is concerned, since there is nothing in law which
Lordship, I'm fully aware what has fallen from your court.
so this order is of no consequence.
No, Lordship, let me answer the query that has fallen from the court in a different way. This order is of no consequences is a subject matter in a 482 petition which are before the Honorable Court.
Yes, this order goes then.
No, Lordship.
So
First thing, Lordship, let us overcome that. The observation of this Honorable Court in a 482 application is fallen that the appellate court order is nullity in law.
Yes.
Okay, Lordship. I'm just making a summation. Lordship, I may be wrong. I may be wrong. But I'm saying this has come in a deliberation in a court proceedings before the Honorable High Court. So, invoking for the larger cause of justice or for the ends of justice, we'll disregard this appellate court order. Because this is happening in course of deliberation before the Honorable High Court. So, if that is disregarded, then what is left? The magistrate's order is left. Can this Honorable Court still not invoke 482 and say, okay, we disregard appellate court?
Why should we invoke? See, 482 will not be available. If you say there is a remedy of revision available, why should we exercise 482? Just because we have chosen the wrong forum. Your wrong will not go to your advantage.
Absolutely correct.
It cannot be interpreted in your favor.
It cannot be. It should not be also.
You have basically invoked the jurisdiction of the appellate court without any specific provision of law. It seems that the appellate court had entertained it, and then we found that basically that exercise of jurisdiction by the appellate court is, as you say, it's totally null.
Fairly considered,
So,
yes.
This is of no consequence. That order goes. Though the order is against you, but then this order goes. Then remains the order of the magistrate, which still is against you. Now you challenge it in a proper way.
Well, leave it to
think over. You think over.
Lordship,
you think over. We may not pass any order right now. Even if we see, just this is a way. You see, like you just give a thought on that.
Lordship is a very. I'm aware of the seriousness of the question.
As far as the appeal is concerned, the status of the order of the appeal is concerned, there is no two other view. That is what this court can say. You also can verify that. And there are
they can't be two views. Yes, Lordship is correct. They can't be two views. This is wrongly invoked. Absolutely.
And if you have any other remedy available against the order of the magistrate, then you should approach that court. We'll give you the liberty to do that.
So, Lordship, can you just give me some time to think it over?
Why not?
I'll think it over because
definitely.
Because I was more into the substantial
Probably
question.
On the last occasion, this angle.
No, this angle didn't. Lordship had expressed. I remember Lordship has expressed this in the first day itself. But we thought because it was in a motion say, we thought if the other side comes, maybe then we could have been. My Lordship, my only concern is this: I can't argue for the state at the same time I can't argue for the accused.
Exactly.
Otherwise, Lordship will kindly give me the liberty. I'll stand here. The moment I'm over, I'll switch my stand
this
there.
complication is created by you only.
No, absolutely correct, Lordship. We're not denying it. We're not denying it because I was under the
You have
impression, Your
heard
Lordship,
the appeal and now you concede that this appellate court had no jurisdiction.
that is an admitted fact, Lordship. And Lordship, only small submission is this, because no substantive law is involved. That Your Lordship, give me time to think. The only reply that I can give is that it's a procedural law, Your Lordship, and procedure is the handmaid of justice. So that can be rectified to the extent that no substantive law is involved.
If
There's no, and I don't have a vested right for procedure.
see, the thing is that whatever you do, it becomes precedence.
That I am aware
If
of.
we
Yes.
relax certain things for certain
Then it
case,
may set a, that I'm aware of
set a
it.
precedence
Yes.
and it will
Yes.
become a regular process.
That part I'm aware. That's what Lordship, I concede there's something wrong. Yes, we can't regularize or make it more. Lordship, can you give me some time? Maybe let's think otherwise, and then maybe court can we can remand the matter back, saying go and approach the right forum.
There is no
My only
there is no
anguish.
question of remand. That will be your choice.
Lordship, my only anguish is this: a very important issue of law is involved, and we are facing problem in whole Meghalaya as to what is to be done. That is the only problem. And Lordship is very well aware that Article 21 will come against us if we don't follow the procedure. And when we are talking about Wildlife Act, Lordship, it's not a state act; it's a central act. So I can't even say why 39 was drafted, why it was omitted.
You cannot go to that question. See, we are very much realistic of the fact that we are very much aware of the fact that we do not legislate law.
Absolutely correct.
Our duty is to see that law is properly implemented. So we are not going to see what was the reason behind why 39 was amended, what 50 was amended. We are not going.
Very true.
to see.
Very true. And Lordship,
We
as
are
a
trying to
state,
determine the law as it is.
Lordship, as a state, I've got very serious constraint because that is something which the central government has to address, and we don't want to go to that area. But as the law stands, if you literally go with the way law stands, it has created a very serious problem in the state of Meghalaya as to what is to be done with the seized property, especially with the omission of power. And then, Lordship, another important, sorry, Lordship, with the grave the leave, another important issue is this: the seizure in the CRPC 451, 457, it always entails seizure made by police. That is where a very important issue is involved. Now, whether we have to interpret whether forest officer will also be a police officer. CRPC will set into motion only when seizure is made by the police officer. Lordship has done a number of cases. We have done also some cases. Custom officer has got the same power. Now, here under the forest officer seizing, if the provision has been omitted, so whether rigor of CRPC, whether we'll have to close.
There is a Forest Act also, isn't it?
Lordship, yes, the whole Forest Act is silent on that. I went through detail wise. So I thought today, at least I could have got a chance to say, maybe a law can be settled on whether forest officer will come with the meaning of police officer. Custom matters, Lordship, we have settled it long time back. But in this issue, the moment a forest officer is not a police officer, then CRPC will not be applicable. That is again a constraint. Otherwise, we'll have to interpret. Now, in all this situation, what is happening in this Lordship? Whenever we seize, how does the state of Meghalaya go about?
We are not concerned with the Forest Act, isn't it?
We are concerned with the
Wildlife Act.
Lordship, we are concerned with the Wildlife Act. Wildlife Act does not talk.
Forest Act is not coming here.
Absolutely not. So under the Wildlife Act also, Lordship, these are all civil officers. So we need an interpretation of whether the officers under the Wildlife Act, the moment he seizes, whether he becomes police officer. The moment we interpret that, Lordship, then all my argument goes, then Lordship is correct. Then CRPC will be applicable. Then first we have to overcome that hurdle. And I was doing some research work to find out.
We may not go into that issue. First of all, you have to overcome that hurdle, whether we can access jurisdiction of 482 or not. Whether we should do.
At this stage, Lordship, at this stage, the appellate order is wrong.
That is the first thing. And second thing, then we will go to the same thing. That whether a seizure would make a vehicle liable to be confiscated or make this vehicle the property of the government.
But I'm seriously constrained by the wrong approach that the state made by filing an appeal. That way we can't overcome. Lordship is correct. I thought I'll just share with you, Lordship, that very important issues involved. We need a quietus either way. Not for a moment, Lordship, because this will give us what is the procedure for a wildlife officer to seize matter. Now we have serious situation all over the Meghalaya, Lordship. Now we don't know what to go about. My concern is that we don't know how we just follow the procedure. The moment the court held police officer, not in this particular matter because we have got serious problem. He can wear the cloak of a police officer for purpose of seizure. then rigor of CRPC comes into picture. But we don't have that.
Anyway, we'll sit it. Just say a straightforward.
Sorry, Your Lordship. Just had to distract a bit.
You can learn. This matter after 2 weeks. Just.
Otherwise, on that point, Lordship, I'll not forward an argument. We are in a wrong, legally we are in a wrong step. We are taking a wrong step.
That is also, you can see it, but then that is probably.
I was just imploring if on the 482, if there is a small window, if the court can see the seriousness and legality of the issue and just lay down a guideline, not only for that purpose.
Okay.
If court finds no, it can't be done, then we go back.
17.